Good afternoon, everybody. Thank you all again for coming to the West Virginia Law Review Symposium. I think it's been a great 24 hours of program so far. I would ask everybody to, as soon as you get your food, to have a seat and get settled. It is my great pleasure to introduce our keynote speaker today. I first became acquainted with her probably more years than either of us would like to admit ago, when I saw that there was a law review article, Does North Carolina Need Home Rule? And I said, oh, that looks interesting. And I read it and I'm like, yeah, this is really good. And then I noticed that she cited my monograph on Dillon's rule. And I'm like, yeah, she's really smart. I like her. And we've corresponded over the years on Dillon's rule and home rule and all of the issues. And so I think this is a great keynote speaker for lunch today. I have to admit, Frayda, you're our second choice. We contacted Judge Dillon to speak today, and he wasn't available. No, Frayda Bluestein is the David M. Lawrence Distinguished Professor of Public Law and Government at the University of North Carolina School of Government, and she operates in that School of Government in some ways like the land use clinic here at the law school, in that they help out local governments and particularly some local government attorneys. So she has a lot of experience both in academia and in the practicing attorney world, in the real world, so to speak. So join me in welcoming Professor Bluestein.
Thank you so much. This has been really great. It's not very often that I get to spend a lot of time with people who are focusing on home rule and Dillon's rule. We're nerds, we get it, but it's nice to be in your company. So again, happy to be here with all of you. The panels and the discussions so far have focused on specific topics within the framework of things that local governments are doing. And we had a wonderful overview from Professor Dillard yesterday about the general overview of what home rule is and how it came to be. And the focus has been preemption. What is it that we are doing, and what is the reaction by states? And I think it's an interesting way to approach the issue. I have decided to focus on one aspect of this, which is what is the role of courts. So when we have situations where local governments are doing things, the state might say, we don't think that's something you can do. Very often these things end up in the court, and the cases are difficult for courts for reasons that I think you might understand after I talk about this topic. So we're in a place right now where there are lots of things that there's just things that local governments are doing that states don't like, and whether you think that's something within the home rule or not, it's the old adage, where you stand is sometimes on whether it's in or out of the home rule authority, where you stand depends on where you sit. So if you're in a local government, you think this is, of course, this is something that's local, it's of local concern to us, so it must be something that's within our home rule authority. If you're the state, you might say, well, this is not something that we at the state think is something that is of municipal concern, and we think it's beyond your authority. So to be fair, it's not easy to have a definition about what home rule is. As Professor Diller explained yesterday, it could be constitutional, could be legislative, it could be that you don't have it at all, as we do in North Carolina. So there's a whole spectrum of authority that local governments have, and of course there's not one definition about what it is. What we can agree about one thing is that it is still the case that local governments are creatures of states, and whatever authority that is given to the local government is within the authority of the state to have and to give. So it's a gift that they give to us in local government, and they don't have to do it. So that's always the thing that we have to, even if we do have some level, whatever modicum of authority we have to understand that we always are creatures of the state. So that's just background. So I'm focusing on the role of the courts. And in that vein, I just want to make one clarification, which I do every time I talk about home rule versus Dillon's rule. It's very common for people to categorize these things as alternatives, versions of home rule. This is a false dichotomy. I know Jesse and I agree about this, and we've both written about this. And I'm just going to go over this one more time, just so that you could all remember it. And when you're at a cocktail party and somebody says, well, is your state a home rule or a Dillon's rule, you can have this lecture that you can have to them say, that is not the right thing to ask. It's neither, right? So the way I explain this to people, and I have to do it a lot because North Carolina is not a home rule state, so we are called within the state a Dillon's rule state, and I have to correct every time they do it. So here's the deal. Home rule is a description of the way a specific state has given, if they have, some authority to local governments, all right? So if you have some authority to do something as a local government, you have some home rule of some kind. And the home rule is the description of the act of the state creating local governments and giving them some authority. So that, and the home rule aspect is that it is a type of authority that is broad in some way, that has gives them some immunity, maybe, but some general authority that is specific to things related to municipal authority. So broad, it comes in different kinds. It could be constitutional, it could be most often just something that says they have authority to regulate and operate within an area of municipal concern. And it's very vague in many cases. Dillon's rule is a rule of judicial construction. It applies to courts, judges, when they are looking at a situation where there is an allegation that the municipality is using some authority, doing something under their authority, and Dillon's rule says that judges should be very strict in interpreting the scope of the authority that the municipality is using. So one thing is, this is how judges should approach analysis of municipal authority or local government authority. It applies to judges. Home rule is what the states give to municipalities if they choose to do so. Everybody got it? Okay, write it down. All right. So, and this is, I say, it comes up all the time because we are in North Carolina, not a home rule state, and we are not a Dillon's rule state. In North Carolina, local governments get their authority by individual statutory authority delegation. We have lots and lots and lots of statutes. The piece that I wrote was to say, we don't have home rule, but we have broad delegated authority. And that was in 2006. And I made the argument in my article that we actually do have broad authority, probably in some cases broader than most cities and counties in other states. We had a very good and strong annexation authority that allowed the cities to annex it involuntarily, annexation, so that they're not subject to a vote. In areas that had developed, so that if you could prove that the areas that you want to annex have been urbanized enough so that they're actually using the services and that they're developed, that you could, with the promise of services, that you can annex people without them having a vote. And that lasted a long time. It created very healthy, financial, great thing for cities. They changed that several years ago, so we don't have that anymore. So I think I would rewrite the statute, the article now. The politics in the state have changed, and I would say at this point we probably do need home rule. But anyway, what we do have are statute by statute authorization, and we also have something that is basically the anti-Dillon's rule, which is a statute called broad construction. So in the 1970s, when the cities and counties statutes were rewritten, they specifically said that, and this is how it reads, it is the policy of the General Assembly that cities of the state should have adequate authority to execute the powers, duties, privileges, and immunities conferred upon them by law. To this end, the provisions in this chapter and the city charters shall be broadly construed, and grants of power should be construed to include any additional and supplementary powers that are reasonably necessary or expedient to carry them out in execution and effect, provided that the exercise of such powers should not be contrary to the state or federal law. So this is just the opposite of what Dillon's rule is. So it's really crazy to say that North Carolina is a Dillon's rule state. So I'm going to set that aside. So what I've been hearing about and the topics that have been addressed in this symposium are focusing, it seems to me, on the effects of states exercising their preemptive authority, whether appropriately or not. And I think it's fair to say that the political divide that exists in many states between cities and their parent states has teed up conflicts between two groups of duly elected bodies. Having created these creatures, states are not happy about how they're behaving. They're bad children, and they're not happy about it. But what we have here is basically a clash of democracy. The situation is, citizens are justifiably enraged and confused. We elected these people to enact laws that reflect the needs and values of our community. Unfortunately, of course, it's not that simple. There's a catch. Unlike states, local governments must have authority to act. States have inherent authority in the 10th Amendment. So the scope of municipal authority is limited and may be preempted by the states. And we hear this from, we've heard about this. We talked about the Charlotte anti-discrimination laws. People in Charlotte, when they got overruled by that, were very confused. The mayor was confused. But that's the way it works, because we have nothing to go on. We don't have anything that says that this is something that we can do without it being preempted. So the scope of state preemption ranges from state to state, depending on the nature of the state laws and constitutions. In a state like North Carolina, preemption is anything. There's nothing at all that prevents the state to override, restrict, ban, whatever. The Constitution gives the legislature the authority to create the boundaries and authorities of local governments, period. In other places where there is some kind of constitution or legislative home rule, there is some sense that there are some things that are actually not things that the state can preempt, but it's very unclear. The home rule provisions, as I mentioned, often just use words like that they have authority over matters of municipal concern. But there's not a clear definition about what that means. And they also include language, something like as long as it doesn't conflict with general law. And again, what does it mean to say something conflicts with general law? So these kinds of definitions end up getting made in the courts. So they have to figure out, what does it mean to say that something is of municipal concern? And courts have done different things with that. It's left up to the courts to establish those standards or those characteristics based on just what they come up with, and courts have come up with different kinds of standards. For example, in Colorado, the analysis is to determine whether something is of local concern or state or mixed. So they have a standard that the analysis is whether if the subject area is purely local concern, or it's a mixed, or it's purely state. And if it's mixed, the court uses a balance approach to determine which law prevails. How difficult it is to make these determinations with no factors or characteristics, nothing to go on. So they just have to make it up. And I think there's even a provision that they've used that says if it's a tie, it goes to the state. So this is stuff that, courts make stuff up, right? That they have to. That's your job. They always say we don't make law, but they do. And in this area, it seems to me that the big problem here is that there's just this hole where we don't have any factors or characteristics or any policies that we can look to the legislation for to decide what is something that is purely local or purely statewide. What happens is, and this is what I think we've been talking about actually for the last day and a half or so, is that cities and their elected officials reasonably go about their jobs responding to concerns of their cities, and values of their citizens. We have this problem. We were just talking about consumer protection, and the argument was, let's do things that are happening in our community. Let's respond to the things that we think we need to do. So, is it the case that if it's something that we think is, something that's happening that it's unique to us, and we think it's really important? I think if I was on the city council, I would say, yeah, that's municipal concern. I don't think that's what the home rule municipal concern is. It can't be that if we think it's important to us, then it's of municipal concern. It seems to me that there are some things we could say were clearly of municipal concern. Examples would be things like the structure of the city council, or possibly, but not always, provisions that we have we might create for our employees, benefits or other kind of things like that. Possibly, you could have a situation where we were talking about utilities and consumer protection. I think it's reasonable to say maybe you don't have the authority to have a broad consumer protection, but you could maybe have rules that apply to the government utilities, because those are part of that. That's the distinction. If we're running the business, I think that would be something that you could do. But beyond that, we have all kinds of very difficult issues that we have. There was a case involving red light cameras. Okay, so cities are interested in doing that. Some people think it's a good idea, some people don't. But roads and other kinds of things have been described as things that are municipal. But it's how would you make that decision? There are all kinds of other things that cities want to do that now are not necessarily part of their internal structure. But I think you could say some safe haven harbor would be things that are related to the structure of the city, the workings of the city, those are kinds of things. There's not much more that clearly, to me, is going to be an easy call as to whether it's purely or exclusively. So what we have here is we have some things that might be like two separate. Maybe it's either this or that. The other side of that is when the home rule provision says not conflicting with general law, the question becomes, does anything that does the the authority that's given to the municipality remove the ability of the state to take on those things? Is it a separate thing, or is there some overlap? Are there some things that are of municipal concern, but also could be something that would be of state concern? So is it a Venn diagram, or is it a one or the other? Those are questions that tee up with all kinds of things that land in court. So I think what we're experiencing now with this divisive and political issues that municipalities are taking on is, what is the limit of the state preemption? And arguments are being made that if this municipality is entering into an area that the state has not done anything about, so there's not a law that they that is statewide, then there's no conflict because they haven't entered the sphere. Well, that's an argument, but it could be that the state has not legislated because they don't think it's a thing that should be regulated. So that is a position that the state has, right? The state has, let's say it's fracking, and the state has not taken or initiated regulations about fracking. So now it comes to your community, and you say, well, if it's going to be here, this is what we want you to do about it. So, that could be in conflict with statewide policy, even if they don't have a law that says that. So preemption is also something that is not specifically enunciated in terms of what the state could do. It's something that the court has to figure out on a case by case. So in North Carolina, for example, although they have all the preemptive rights, the statutes specifically say that with respect to the authority that they have, that preemption is enunciated in this way. They specifically say that they can't regulate the ordinance, the things that they can't do. The ordinance cannot make unlawful an act, omission, or condition which is expressly made lawful by state or federal law. It also says that the ordinance cannot make lawful an act, omission, or condition which is expressly made unlawful by state or federal law. And then they have occupies the field language, where the ordinance purports to regulate a field with the state, that the state or federal law clearly shows a legislative intent to provide a complete and integrated regulatory scheme to the exclusion of local regulation. So that's in the statute in North Carolina. You don't have that in a typical constitutional or legislative grant of home rule. So the courts are going to have to figure out, is this something that is conflicting with state policy, or or can it be that's even without having a legislated or policy on the books, that the state can preempt nonetheless, just because they think it's not something that is purely a municipal concern. So and these are all questions that are being teed up in cases when we're seeing these preemptive things having. And again, my point here is how is a court to determine who gets to be, who's right? It seems to me that some of these cases are teeing up in a way that it seems like it's the argument of the municipality is, well, we got there first, right? So we're regulating this. The state hasn't regulated it, and therefore it's not a conflict. I don't think that's if the matter is something that is and has a statewide effect. I think there's an argument that even if you got there first, this is not something that is of municipal concern, or at least solely municipal concern. And in that situation, if there's nothing explicit in the home rule provision, the state still has preemptive authority, it seems to me. So again, these are my thoughts about what the high bar that the courts have and the difficulty they have, especially with respect to being consistent with each of the different types of things that, how do you decide whether some kind of consumer protection issue or regulations on businesses or other kinds of things. Some of that, we talked about the gun rules that people were thinking about, regulating guns. The guns don't stay within boundaries very well, and we talked about some of the issues that could come into play if one city has one rule and another city has another. There are arguments to be made that some of these things that are very, very important to cities and their elected officials, and it may be that there are some reasons that those might be not be able to be sustained under the municipal concern. And again, what I'm teeing up here is that we just don't have a good idea of what that means, a good enough idea of what that really means for courts to be able to be consistent and making these policy decisions about, well, this is a local thing and this is not a state thing, or vice versa. The fact that some of the conversations and the talk that we've had about things that local governments are doing, I heard a couple of times that this is something that cities want to do because the state isn't. That seems to me almost admitting that the state could, and if the state is not doing it, we're going to do it. And I'm not sure that is going to be a very strong argument if you are in court and you're trying to prove that this is something of municipal concern. And again, what's the ambiguity here is, does it have to be only of municipal concern, or can it be something that is something that the state could also do, but hasn't thought fit to do it? So, and that's been described in some of the cases and the articles about that they've abandoned that. And so because they've decided not to, it's up to us to take that up. And I don't know whether that is going to pass muster. Again, in the absence of any definition of what municipal concern means. And a couple of times, as people have been talking about the policy issues that are really high priorities for many local governments, not to say that it's not a good idea for for those aid, those entities to take them up. There still are, even though this is very important to us with this local government, there are externalities. We've had people have been talking about some of the externalities that can create. And so that's another thing that courts might think about in talking about, is this something that is strictly a local thing, or to the extent that if we do this, this has an effect on other cities or the state as a whole. I can imagine courts saying, well, that's a reason to say that this is something that the state should have the final word on. My thinking about this is, I'm interested in people's thoughts about what kind of standards should there be for courts to follow. Circling back to Dillon's rule, I mentioned early that it's not either home rule or Dillon's rule. There are courts who have applied Dillon's rule to an analysis of something that has been challenged in a home rule state. And so I can imagine that a court might say, well, maybe we should look at Dillon's rule as a way to figure out whether this thing that they're doing is within the scope of the home rule provision that applies, whether it's constitutional, whether it's legislative. I can imagine courts saying, well, we should construe these delegations strictly and not broadly, because that's what Dillon's rule says for them to do, absent any other kind of standard or characteristics. Sorry. I don't know if other people have thoughts about how we fill this void that is, I think, because of the increase in preemption. What is it that courts should be looking at in the absence of anything else to decide what the standards should be, as in terms of, is this something that is local? Is it something that is conflicting with the state policy or the lack thereof? In North Carolina, it's not a problem because the state can preempt everything. So I'm going to stop right there and see if anybody has any thoughts about what I've said so far.
Hello, my name is Thomas Frederick. I'm an associate editor on the Law Review. I guess my question is, in states that are not constitutional home rule states, in theory, can't those states preempt municipalities and just about anything? They just have to change the home rule statute to begin with?
Yeah, that's a great question. There is a big difference between a constitutional home rule provision and a legislative one. So if you're talking about legislation, yeah, they can say you can't do that. And when I say that, I'll tell you a story in a minute. But yeah, I think the constitutional home rule is stronger in the sense that it's not in the control of the legislature, and it also creates a right, arguably, for local governments to have that authority. So that's a stronger argument. The story I was going to, in a legislative in a place like North Carolina and in the legislative, it's pretty much up to the legislature. So when I'll tell you a story. My husband is the oldest of 4 children, and he was playing a game with his sister, his younger sister. It was one of those board games they used to have, and they had the rules on the inside of the box. And so whenever they were playing, and if he was losing, and his sister would make a move, he'd say, "You can't do that." And she said, "Well, I can do that." He said, "No, you can't do that." He said, "Look at the rules." And he had written on, like, it's rule number 8. And he had written on number 8, "You can't do that." So that's pretty much the way it works if you have legislative, they can say that, they can change the rule and say you can't do that. But it's harder to do that in the constitutional. So I don't know what the answer is in terms of how we deal with the lack of, for better or for worse, factors or characteristics that the courts could use to give them something to go on. It varies from state to state, and it seems to me it's going to be increasingly unhappy results, mostly for local governments, because there's just nothing to go on. And they're probably going to look to things like, preemption and Dillon's rule and other kinds of things to make it work. But I think that the thing, my observation, especially with all of the wonderful conversations that we've had with talking about things that cities are doing, I think because of the divisive and redistricting and gerrymandering and very, very, people being on opposite sides of the political spectrum, we're going to have a lot more situations where we have local governments doing one thing and their legislature saying, no, we don't like that. And I think if it's not, unless what my conclusion is that these are things, the things that local governments are doing are very important to their communities, and it feels like we're setting people up to be disappointed. So this is a clash of democratic things. We have elections. We create these municipalities. We put people in there to make decisions, to make laws, and then we say, oh, you can't do that. And I think that it's going to be hard in many of these situations for the municipality to win a fight with the legislature, making a point that it's a municipal concern. I think it's likely that courts will be strict on that and look at things that are specifically and maybe just completely solely municipal. If it's something, and many of these things are, that are affected, that are statewide issues, it's going to be hard, I think, for the preemptive. It's going to be hard to challenge the preemptive actions. Anybody have different thoughts? Anybody? Yes.
Thank you. Sheila Simon from Illinois. I'm wondering if the advent of hyper preemption might actually allow us to shift a burden to say, because they could do that, because they could monopolize the field even by monopolizing the field and not doing anything, that we should assume that the municipal government has the power until that kind of absolute monopoly has been exercised by the state legislature.
So The problem with that is, I mean, I think it gives us some impetus to make that argument, and but if the delegation of authority is that this is something that is specific to municipalities, that doesn't help. You still have to make, just because we got there first doesn't mean, you know, that, I don't know. But the other thing, okay. The other thing is, some of us were talking over beers and wine, this might be an impetus to think about how we might change or advocate for change, because the concept of home rule is very narrow, and I think it's been a long time since people sort of had that idea. They were looking for something, some sort of autonomy. I think, I don't know where we get where the political will would be, but it might be time to think about whether, because cities and counties and local governments have such a different and robust effect on the states and the people that live there, that there may be some possibility of having a constitutional, national constitutional discussion about, you know, the argument I would make is, here we create these political subdivisions, we arm them with money and you know, elected officials, and then we say, you can't do that. It might be time to say, is there some point where we would say that maybe these people, these entities should not be completely controlled by states? I don't know how we do that, but it seems to me it's coming close to a tipping point. And we're not arming our courts with very much to go on. So it might be a political thing, but it's just that's my take on what's happening, and the role of the courts, I think, is going to be very important because a lot of these cases are pending now, and again, the courts are doing different things in different states. So good luck, all of you all. Hope that wasn't a downer, but those are my thoughts. Thank you.
Thank you, Professor Bluestein. Again, we're going to do one more switch back over into the Lugar courtroom. If you do want food, there is some in the back, so please go ahead and try to finish that off, and we will start in about 10 minutes over there.